Claire Curran.
Thank you, Mr. Chair. So, Mr. Chair, there's a number of pieces of Part 2 which I would like to speak to, but I'd like to turn my attention first to the supplementary order paper tabled by the Minister, and to which I'm hoping the Minister will speak, because it SOP number 67, Part 2, which inserts new clause 14 and new subparts 2 and 3. And I'm hoping the Minister will speak to this, because this is a completely new clause in the bill, and there's been no ability for there to be a debate or a discussion in a select committee, and it creates a completely new part to the bill, which ensures that New Zealanders who assist foreigners to commit sexual acts against children overseas commit an offence under New Zealand law. And this amendment, as the Minister has said in her SOP, is in response to a recent Supreme Court decision, which was in 2014. I think, I can't find the exact date, but I think it was in August, by memory, in 2014. And so the ruling in LM versus the Queen is that a New Zealander who assists a non-New Zealander to engage in sexual conduct with a child overseas would not be guilty of an offence under New Zealand law. And this SOP, as I understand it, is meant to address that, and therefore if their principal offender is neither a New Zealand citizen nor ordinarily resident in New Zealand, they would not have committed an offence under New Zealand law. Therefore, the court is unable to convict an assisting party because there's no offending to be party to. So specifically, the amendment provides that party liability where the principal offender is a foreigner who has not committed an offence under New Zealand law, and accessory liability for assistance given by a New Zealander to a foreigner after the offence has been committed. Now, I've done the Minister's job for her because I've just read out the amendment to you. My question is, and you know, by all intents and purposes, this looks as if it's an amendment which is addressing, which has been raised in a previous case as another gap in the existing law, and it's seeking to address that gap. My question is to the Minister, and I'm hoping that in good faith that she will be able to address this, is there precedent for this, and the context for it, and where the recommendations came from, and what ability she's had to receive any reports on it. Because I think when you put a completely new amendment into a piece of legislation at the committee stage, then you should be prepared as the Minister to get to your feet and actually address the context for it, so that we're not just sliding something new into the law that's had no ability to be tested, that's had no ability to have officials provide advice around it, and it's had no ability for there to be any discussion through the select committee process. So I'm hoping that that's what we'll hear from the Minister on during the debate in this part of the bill. I also want to address clause 13, which in part 2, Mr. Chair, which is the new section 124A inserted indecent communications with a young person under 16, which creates a new offence under the Crimes Act 1961 of indecent communication with a young person and anyone under the age of 16. And this new offence also applies where the person charged communicates indecently with a police constable, believing the police constable to be a young person. And I think we all know that this is basically where it occurs in predominantly, as I would understand it, in an online environment where there's the ability to, where there's an attempt to try and trap, Mr. Chair,
Okay, Karen.
the perpetrator into revealing their true purpose, and which is to commit an offence. Now, this falls under the category of the gaps in the law which this bill is trying to address, and which we support. The submitters who submitted on the Select Committee all seem to support this offence and seem to consider it to be a positive step towards curbing the culture of child exploitation through the internet. But they stated that it was worded in a way that allowed for new technologies and form of social media to be included as they appear, and I think that's very sensible for this legislation, because it may very well be that there will be new forms of media that we don't even know about yet that will emerge, where these kinds of offences are being perpetrated, and young people are being preyed upon by the abusers, and I think it's critical that we're writing legislation that can provide some kind of window to the future, and it's not always retrospective. So I applaud that and think that that's important. One of the submitters, which is the Legislation Advisory Committee, the LAC, agreed that there was a gap in the law that needed to be remedied, pointed out or considered that the explanatory note which described the gap as being between objectionable publications offences and the sexual grooming offence was inaccurate, and said that it did not think that it was clear that the objectionable publications offence only applied if the offender makes a record of the communication as distribute in section 123 of the Classification Act appears to capture the same action required in the proposed new offence. The comment was that there was a defence available where reasonable steps are taken to ensure the young person is over the age of 16, and I think the officials did go to some steps to reassure the committee. Even though I didn't sit on the committee, it does appear to me that there was an attempt to ensure that while there was a legislative gap, there's a legislative gap exists where no record is made of indecent communication, because section 123 of the Classification Act only relates to publications, and the definition of publication in section 2 of the Act was such that in order to establish an offence against that section, a record of the communication must be deliberately kept by the offender. I think that the discussion in the Select Committee, where they inserted that new section 124A3 into the Crimes Act, providing the defence that before making the indecent communication, the person charged took reasonable steps to find out whether the young person was 16 years or older, and believed on reasonable grounds that they were at the time of communication, and that's where the defence lies. So there's certainly this section of the Act, which really does go some way to addressing, well, it goes quite a long way to addressing the entrapment and concerns that submitters had, where the person charged communicated indecently with a police constable, believing that the constable to be a young person. And I think that's the issue, and the concerns that were raised at the Select Committee, that to what extent could the police undergo that investigation with the person on the other end not knowing that they were being entrapped, but where they didn't make an attempt to find out whether the person was under 16 or not. And I'm reasonably comfortable that where that ended up is probably the right place. But in particular, Mr Chair.
The Honourable Amy Adams.
Mr Chair. Thank you, Mr Chair. I did just want to take